Mr. Barr. Good morning, sir. I appear today on behalf of the inquiry with Ms. Gargiter. Mr. Menon, King's Counsel, appears on behalf of an applicant. Mr. Greenhall on behalf of applicants. Mr. Lowenthal, who we are anticipating is going to be joined by Ms. Kilroy, King's Counsel, on behalf of certain applicants. Ms. Heaven on behalf of the non-state core participant group, Mr. Skelton, King's Counsel, with Ms. Mannion on behalf of the Commissioner, Mr. Sanders, King's Counsel, on behalf of the designated lawyers, teams, officers, and Mr. Whittam, King's Counsel, on behalf of those former members of the SDS represented by DAC Beechcrofts. Sir, for this restricted reporting order hearing, you have two notes from Ms. Gargiter and myself, dated the 13th of March and the 10th of April. You have the Commissioner's legal team's written submissions of the 2nd of April, and a letter from the BBC dated the 3rd of April. Those represented by the designated lawyers team, DAC Beechcrofts, and the Home Office chose not to make any submissions in writing. The applicants have submitted their applications, but have not been given an opportunity to respond in writing. Rather, the intention is that we start today with their open oral responses to the written submissions of the Commissioner and the BBC, insofar as they can be made without defeating the purpose of their applications. So you may also wish to hear from the state participants in response, not only to anything said today by the non-state core participants, but also in response to the media submissions. So you'll be aware of the BBC submissions, and I remind everyone that in tranche 1, after phase 1, that media bodies approved by the inquiry were provided with the full hearing bundle in advance, subject to a restriction order. The bodies which received the bundle in advance were the BBC, ITN, The Guardian, The Telegraph, the Press Association, the Daily Mail, and Times Media. And if we maintain that approach in tranche 2, it would obviously be subject not only to a restriction order, but also to any reporting restriction orders that you make following today's hearing. After the open session, sir, we plan to go into a series of private sessions, hearing separately from each of the legal teams acting for applicants before returning for a concluding open session. So unless there is anything further I can assist you with at this stage, I think it is time to hear from the non-state teams.
Certainly, thank you. Mr. Greenall, are you going to go first?
I certainly can, sir. In relation to the general principles, I endorse what's been submitted by counsel to the inquiry. In relation to the application from the BBC, on behalf of those clients I represent, I would dispute that the granting of any reporting restriction order would amount to granting anonymity via the back door, and that, in my submission, any reporting restriction order can be implemented in such a way as to allow for the media to have access to the relevant material and to publish an accurate account of the inquiry without providing details which would identify court participants in ways which would breach any reporting restriction order that might be made. But I have nothing further to say on the general principles.
Do you accept or reject or wish to qualify the suggestion made by the BBC that the identified traditional media representatives who have received bundles in the past should do so at the start? It will enable them, I think, more accurately to understand what is going on and to be able to report in due course more accurately about what has occurred. Up to now, the inquiry has experienced no difficulty with compliance with orders that have been made.
Yeah, so we are neutral on that matter.
You're neutral. Thank you. Mr. Mellon.
Good morning, sir. We have no submissions of a general nature to make at this stage. In relation to the point that you just raised with Mr. Greenall, we too are neutral. We don't raise any objection to the media having the tranche 2 bundle in advance, subject, of course, to any restricted reporting orders that you make as a result of today's hearing.
Undoubtedly that is so, but my understanding of the application is that they wish to have the bundle at the start of the hearings so that those who are attending and reporting upon them can understand what is going on, but of course subject to restriction orders that will prevent them from publishing those parts of the bundle in respect of which restriction orders of one kind or another are made.
Yes. We have no objection or observations in relation to the timing of the disclosure of that bundle to the media.
Thank you very much indeed. Most helpful. Mr. Lowenthal, I think. Mr. Lowenthal?
It's actually, I have managed to arrive a bit earlier than expected.
Oh, I'm so sorry. I do apologise. I saw you there, and I forgive me. That is discourteous of me, and I do apologise. Please say your piece.
Thank you. Well, since I wasn't expecting to be here for this bit of the session, I'm not going to say very much. But what I just want to address that last point.
Yeah.
Of the bundle. I don't think we are in a position to agree that at this stage, and I would like to address you further on the mechanics of that issue of the bundle going to accredited journalists in advance in the restricted sessions that we'll be holding later.
Certainly. That is something I think to which we may return in the final public session after I've had the heard submissions in private.
I would be very grateful if that were possible.
Yes. Anything else?
Other than that, I mean, I think that it's going to be better for me to address points of principle arising in those private sessions, and then to draw them together at the close, if that's all right with you.
Of course it is. You would adopt whatever course you consider best. I'm content with that.
Yes. So subject to that, I don't propose to say anything further now.
Right. Do any of the state core participants who have not put in written submissions wish to say anything at this stage? In that event, I think that concludes this open session, and we will now go into a series of private sessions.
Sorry, sir, just to interrupt you. I do have some short points to raise. Clearly, they can be raised now, or they can be raised later on, because they are just general points on behalf of the group. So whatever would suit you best, sir.
I think it's best if they're ventilated now, so that when we're in private session, we can take them into account.
Well, so I've nothing to add in relation to the query you raised with Mr. Greenhall. Obviously, we remain neutral, and we haven't had the opportunity to take full instructions on media, and nothing to add to CTI's principles and the BBC's representations. Can I just say a few comments, please, in relation to CTI's note at paragraph 16, and this is really for the public record. I think and this is the note for, this is the inquiry's first note, the 13th of March 2024, where it stated that disclosure was started in earnest, I think, in March 2023, and I think it notes that it's almost complete as at the date of this.
Forgive me for interrupting you, because for some reason the sound has been set up so that it is very mute and there is noise outside the window. I didn't catch all that you said then, and with the greatest of apologies, could I ask you to repeat it?
That's fine. I'll raise my voice and start shouting. No, it's just to respond to CTI, something CTI has said in paragraph 16 of the note, and it's the first note of the 13th of March 2024.
Yep.
And it really is just to put on record. Obviously, at that part of the note, it says that disclosure was started in earnest in March 2023 and is almost complete as at today's hearing. And of course, you'll know that certainly the non-state core participants have been raising concerns for some time about the speed of disclosure to them as compared to other CPs, in particular the police. And I think certainly as at the 22nd of January 2024, many non-state CPs still had received no disclosure, despite receiving Rule 9 requests, with much remaining outstanding. And I think it's fair to say, certainly we are, as the legal team for the group, understand that several non-state CPs are still waiting for disclosure to respond to their Rule 9 requests. So I've just been asked to put that on the public record today, just in response to that point of CTI's note. Now, there's just 4 very short points, if I may develop them. The first is this: if reported restriction orders are to be granted, can the inquiry please set down a clear procedure of exactly what will happen prior to onward publication, and commit to giving affected non-police state core participants the right to make written representations? So for your note, some procedure very briefly was set down in a letter from the inquiry on the 15th of January 2024, but that simply indicated that those affected may be able to make submissions. So it's really just a plea for a clear procedure and a right to make written submissions, and I'm sure that will include the media as well. Now, the second practical and procedural point is this. So at paragraph 16 of their written submissions, the Metropolitan Police make the point that core participants should not be fettered in making submissions to the inquiry in opening and closing in respect of any material subject to an RRO. So 2 points arise here, sir. First, there is the practical point raised by the Metropolitan Police of having either a closed addendum or inquiry redaction prior to the opening and closing statements, both of which we would agree are acceptable solutions. But there is a second point, and this relates to ensuring that closed hearings, if there are to be any more, do not further limit the ability of non-state core participants to address you on the totality of the evidence. So of course, the Metropolitan Police will have a global perspective of all the material, including those subject to any RRO, when they make their final submissions to you. And this will obviously mean they can analyse all of that evidence in totality. Now, the Metropolitan Police are indicating today that they will oppose any attempt to exclude them from a hearing following the grant of an RRO. And I'm not making any submissions on that point at this stage, but simply this: if there are to be a series of further closed hearings for non-state court participants, or hearings with restricted attendance where certain non-state court participants are to be excluded, can the cooperating group's solicitor and counsel team please attend any of those hearings? Clearly that would be subject to consent from the affected non-police state court participant. But this is to ensure that the wider state group is effectively in the same position as the Met in being able to see all of the evidence. Now, this is likely to be necessary to ensure that any issues of wider relevance to the group, so for example, issues around tradecraft that might come up during that restricted and closed hearing, if that does come up, clearly if the non-state cooperating group is present in those hearings, that can be identified, connections can be made if necessary, and that can then be addressed in our group submissions to you in closing, and that would obviously be in a closed annex if that was the appropriate procedure that was adopted by the inquiry.
May I interrupt your flow there? You, as I understand it, submit that there should be representation by non-state court participants in hearings that are closed, even where the closed hearings are held for purposes of protecting serious public interest requirements. I simply, I'm afraid, cannot accept that. This is an issue that has been canvassed in correspondence before, and the suggestion was made that something along the line of a special advocate could be nominated. But I'm afraid you have to depend upon counsel to the inquiry to represent wider interests at closed hearings.
Sorry, just to be clear, I obviously wasn't clear in my submission, so I'm not rehearsing that argument, of course, in relation to the restriction orders. This is a narrower point. So this is if there are to be further closed hearings pursuant to the grant of an RRO for a non-state court participant. So
I do apologise, I misunderstood.
I'm not seeking to re-argue the issue around attendance at closed hearings that we know happen pursuant to the RO. So this is a new ones for the benefit of a non-state court participant granted an RRO. Clearly in that situation, provided they consent, we would simply ask as the coordinating group to be permitted to attend any of those hearings if they are to be closed, so that we can pick up the crossover issues for the group. So it was simply that limited submission, sir.
Give me that. I now understand the point, and I had misunderstood, and thank you for putting me right.
My mistake, sir. So final point is this. It's just to seek clarity on something that's said in paragraph 7 of Counsel to the Inquiry's note. So that's the first note that I've already quoted from. And I'll just read it out to you. It's paragraph 27, and it's dealing with the inquiry bundle. And it simply states this, and this is the last sentence: if orders restricting attendance at the open hearings are made such that affect other CPs, for example, those not involved in the events in question, then the relevant parts of the hearing bundle would need to be withheld from them. So it's simply a plea for a better explanation of what is meant there, because we don't understand. Our understanding was that there would be one hearing bundle subject to privacy redactions, but certainly this sentence at paragraph 27, the last sentence, would appear to suggest that there may be other versions of the hearing bundle that are going to be in circulation, some of which have sections withheld. So it's just really a plea for clarity, obviously not immediately now, sir, but at a later date, just so that we can understand actually what is being meant here in paragraph 27. Thank you. Those are my submissions.
Certainly. Does that conclude what you have to say in this opening session?
It does, sir. Thank you. Those are my submissions for the opening session.
Thank you very much indeed. Is there anybody else who wants to say anything in this open session, or shall we now go into the private sessions that I anticipate will take a certain amount of time? Then we'll do that. The open session is closed.